I like this one. Rick from Naples. Exactly how broke do I have to be to file bankruptcy? What if I have some money in savings? Rick, it doesn't matter how broke you are. What it comes down to is what's left on the table. When I talk to a client, the first thing I tell them, look, I got to look at your assets. I need to know what you own because the law says I'm allowed to exempt certain assets. So, one of the ones that people are always worried about is their 401k. Am I going to lose my 401k or my IRA? I've done bankruptcies for folks with $600,000 in an IRA or, more than that in a 401k. Those assets are exempt, meaning, let's call this the IRA. It's off the table. You file bankruptcy, you disclose it, and then you exempt it. You take it off the table. Then I take off my IRA. Then I say, okay, well, my house is exempt, or, my bank accounts are exempt. And I'm constantly trying to take as much off the table as possible. So really when you're saying I'm broke, how much money, what if I have some money in savings? Well, let's say you have $1,000 in the savings account, and I have room to exempt that $1,000 from the bankruptcy estate, meaning I'm taking it off the table. So it doesn't matter. Just like the $600,000 IRA. That person wasn't broke, but that asset's exempt. It's not even taken into consideration in the mix of things. So being broke, while it may be, good thing if you're filing bankruptcy, being broke is not the rule, I guess you want to say. You want to look at the assets individually and say, are they subject to an exemption? If I can exempt them, they're off the table. And then we have to look at what you really have left on the table. If you have no assets left on the table, then you're considered a no asset case, and as long as you meet the other requirements, you may be eligible to file a Chapter 7. Alternatively, if you do have a lot of assets left on the table, you may want to file a Chapter 13 and say, hey, I want to keep these assets, so I'm willing to pay my creditors at least as much as I want to keep over here. And then as long as you have a valid plan, it meets all the requirements under the Chapter 13, the judge will confirm your plan and you get into what's called a repayment plan as proposed in your Chapter 13 plan. So what you're saying to the court is, here's how I want to pay my creditors and here's how I can afford to do so. The Chapter 13 trustee is going to look at your plan and make a recommendation to the court and say, Judge, I think this plan is confirmable. If the trustee says, no, I don't think this plan is confirmable for one of the reasons, then that's going to be a factual dispute or a evidentiary dispute that we're going to have in front of the judge. And the judge will ultimately make a recommendation. Does that happen? Sometimes, not a lot. Usually the requirements are easily met, so we can prove our case to the trustee saying this is why our client's only paying X, Y, and Z, and here's the reasoning behind it. And if the trustee agrees with us, then it goes right to confirmation and the judge puts a stamp of approval on it in the form of an order confirming the plan. So it's pretty simple.